Welcome to Fundamentals of Cybersecurity, CSCI150N, Chapter 25, Privacy. I'm your instructor, Peter Keurig. In this chapter, you will learn how to define privacy, identify privacy laws relative to computer security in various industries, describe issues associated with technology and privacy, explain the concept of personally identifiable information, PII, craft a privacy policy for online records, and recognize web-related privacy issues. This lecture will outline privacy, personally identifiable information, PII, U.S. privacy laws, non-federal privacy concerns in the United States, international privacy laws, privacy-enhancing technologies, privacy policies, web privacy issues, and privacy in practice. Privacy can be defined as the power to control what others know about you and what they can do with that information. In the computer age, personal information forms the basis for many decisions, from credit card transactions to purchase goods to the ability to buy an airplane ticket and fly. Although it is theoretically possible to live an almost anonymous existence today, the price of doing so is high, from higher prices at the grocery store due to no frequent shopper discounts, to higher credit costs, to challenges with air travel, opening bank accounts, and seeking employment. Information is an important item in today's society. From instant credit to digital access to a wide range of information via the Internet, to electronic service portals such as e-commerce sites, e-government sites, and so on, our daily lives have become intertwined with privacy issues. Information has become a valuable entity, for it is an enabler for many functions. The creation of an information-centric economy is as dramatic a revolution as the adoption of money to act as an economic utility, simplifying bartering. This revolution and reliance on information infuses information with value, creating the need to protect it. Personally identifiable information, or PII, is a set of elements that can lead to a specific identity of a person. By definition, PII can be used to identify a specific individual, even if an entire set is not disclosed. As little information as zip code, gender, and date of birth can resolve to a single person. This includes, but is not limited to, name, address, phone number, fax number, email address, financial profiles, medical profile, social security number, and credit card information. Sensitive PII is so sensitive to disclosure and resulting misuse that it requires special handling to ensure protection. Data elements such as credit card data, bank account numbers, and government identifiers, including social security numbers, driver's licenses, and so on, require extra levels of protection to prevent harm from misuse. The same thing also goes for medical information. As privacy is defined as the power to control what others know about you and what they can do with that information, and PII represents the core items that should be controlled, communication with the end user concerning privacy is paramount. 3 words govern the collection of PII. Notice refers to informing the customer that PII will be collected and used and/or stored. Choice refers to the opportunity for the end user to consent to the data collection or to opt out. And consent refers to the positive affirmation by a customer that he or she read the notice, understands their choice, and agrees to release their PII for the purpose explained to him or her. Quite often, we agree to a service or something on the internet without properly reading the terms of use or terms of service, and in there usually identifies what your rights are and what your personal identifiable information is going to be used for. The next time you sign up for an internet service of some sort or an account, read the entire terms of service and see if that's included in there. It should be. The United States has a lot of laws that govern privacy. It starts with the Privacy Act of 1974, which was an omnibus act designed to affect the entire federal information landscape. This act has many provisions that apply across the entire federal government, with only minor exceptions for national security or classified information, law enforcement, and investigative provisions. This act has been amended numerous times, and you can find current detailed information at the Electronic Privacy Information Center. The Freedom of Information Act, or FOIA is what we often refer to it as, was passed in 1996, is one of the most widely used privacy acts in the United States, so much so that the acronym FOIA has reached common use. FOIA was designed to enable public access to U.S. government records, and public includes the press, purportedly acts on the public's behalf, and widely uses FOIA to obtain information. FOIA carries a presumption of disclosure. The burden is on the government, not the requesting party, to substantiate why information cannot be released. Upon receiving a written request, agencies of the United States government are required to disclose those records unless they can lawfully be withheld from disclosure under one of 9 specific exemptions in FOIA. The right of access is ultimately enforceable through the federal court system. The 9 specific exemptions are: 1. National security and foreign policy information; 2. Internal personnel rules and practices of an agency; 3. Information specifically exempted by statute; 4. Confidential business information; 5. Inter- and intra-agency communication that is subject to deliberative process, litigation, and other privileges; 6. Information that, if disclosed, would constitute a clearly unwarranted invasion of personal privacy, so personnel records or something of that sort; 7. Law enforcement records that implicate one of a set of enumerated concerns; 8. Agency information from financial institutions; and 9. Geological and geophysical information concerning wells. In other words, they don't want you to be able to poison or tamper with wells. FOIA is frequently used and generates a tremendous amount of work for many federal agencies, including agencies that I've been at. FOIA requests constantly are being fielded and keep personnel busy, which often results in delays for the requests. So that's kind of testimony itself and the effectiveness of the law. Family Education Records and Privacy Act, or FERPA. Student records have significant protection under Family Education Records and Privacy Act of 1974, which includes significant restrictions on information sharing. FERPA operates on an opt-in basis, as the student must approve the disclosure of information prior to actual disclosure. FERPA was designed to provide limited control to students over their education records. The law allows students to have access to their education records and opportunity to seek to have records amended, and some control over the disclosure of the information to third parties, for example, to banks and other lending organizations that want to provide you with federal student loans. You, as a graduating high school student, might have gotten some information, but that was usually because you signed up for financial aid and checked a box that your information could be shared with third-party financial institutions. It was originally designed to protect K through 12 school-level students, the reason being that you're typically too young to make a legal decision for yourself on the disclosure of your information. It recognizes parents as part of the protected party. FERPA provides parents with rights to inspect and review their students' education records and the right to seek to amend information as necessary. And it also allows parents to decide on the disclosure of PII for their students. When a student turns 18 and enters a post-secondary institution at any age, those rights under FERPA transfer from the parents to the students. So you can expect some FERPA rights when you came into college. The U.S. Computer Fraud and Abuse Act, or CSCI. The U.S. Computer Fraud and Abuse Act started in 1994 and has been amended several times. And privacy laws such as the European Data Protection Directive have several specific objectives, but one of the main ones is to prevent unauthorized parties access to information they should not have access to. So fraudulent access, or even exceeding one's authorized access, is defined as a crime and can be punished with both fines and jail time under the CFAA. Although the CFAA is intended for broader purposes, it can be used to protect privacy related to computer records through its enforcement of violations of unauthorized access. The U.S. Child Online Privacy Protection Act, or COPPA, was originally designed because of disclosure of minors' information due to social media and online services. Children lack the mental capacity to make a responsible decision concerning the release of PII, So the act was passed in 1998, specifically addresses this privacy issue with respect to children accessing and potentially releasing information to the internet. Any website that collects information from children under the age of 13, even simple web forms to allow follow-up communications and so forth, is covered by this law. Before information can be collected and used, parents' permission needs to be obtained. And this act requires that sites obtain parental permission, post a privacy policy detailing specifics concerning information collected from children, and describe how the children's information will be used. This is actually why, if you noticed, social media sites like Facebook doesn't allow children ages 13 and under to apply for an account. You have to be 14 or older to create an account because of COPA, and they don't want to have to deal with the release of your personal information because they are in the business of developing personal profiles and selling it for advertising or using it for the means of generating advertising. And that would be a violation of COPA. The Video Privacy Act, or VPPA, considered by many privacy advocates to be the strongest U.S. privacy law, was passed in 1988, provides civil remedy against unauthorized disclosure of personal information concerning videotape rentals and, by extension, DVD and game rentals as well. This is a federal statute crafted in response to media searches for rental records associated with a judge when he was being nominated for the U.S. Supreme Court. Congress was upset with the release of the personal information or the rental information for this candidate, and so it was drafted in order to protect people's rights not to have their viewing exposed to the public. So you have a right not to have your rental information, and my understanding is this is extended now to Netflix as well. So your viewing habits on Netflix is not subject to being reviewed publicly or being released publicly. But that doesn't mean it's not being tracked. I mean, Netflix is going to know who's watching what videos at what time, and it is always subject to law enforcement review if necessary. Then you have your Health Insurance Portability and Accountability Act, or HIPAA, which was passed in 1996, which provides certain provisions for protecting healthcare information and provides financial penalties for healthcare organizations or companies or organizations that hold healthcare information who do not provide enough protection and results in information being lost or leaked. The Graham-Leach-Bliley Act, GLBA, is a financial privacy act that financial institutions are subject to. It's about how much information they can and cannot share about you with other third parties regarding your finances and your financial transactions. California has its own laws regarding privacy. Also, Massachusetts does. It's not in here, but it's one of the ones that's out there. Then there's U.S. banking rules and regulations. There are various rules and regulations within the banking industry to protect you against fraud, disclosure of your personal information, and identity theft, and who has the liability and the financial responsibility with identity theft. Payment card industry data security standards, known as PCI DSS. This is touched on a little bit in Chapter 24, but major credit card firms such as MasterCard, Visa, and American Express got together and designed a private sector initiative that deals with privacy issues associated with credit card transactions. And as part of the requirement in order to do credit card transactions, companies or organizations doing the transactions must agree to a certain level of privacy protections for the users. And in some ways this was a means of them cutting off or jumping the gun before the government stepped in and passed such regulations. They're basically self-governing their own industry. And failure to meet their contractual obligation can result in you not being able to continue processing credit card transactions, or could also result in a loss of protection when it comes to credit fraud if you fail to meet the proper protections. There's the Fair Credit Reporting Act, passed in 1998, brings some privacy protection to consumer credit reporting. This act requires that agencies provide consumers notice of their rights and responsibilities, and the agencies are required to perform timely investigations on inaccuracies on consumer credit. The agencies are also required to notify the other credit agencies when consumers close accounts. The Act also has technical issues associated with data integrity, data destruction, and data retention, and third-party access to data. The Fair and Accurate Credit Transaction Act, FACTA, was a follow-on to the Fair Credit Reporting Act and was passed to enact stronger protection for consumer information from identity theft, errors, and omissions in the credit industry. It amends portions of the Fair Credit Reporting Act to improve the accuracy of consumer records in consumer reporting agencies and to improve timely resolution of consumer complaints concerning inaccuracies and how to make businesses take reasonable steps to protect information that can lead to identity theft. There are non-federal privacy concerns in the United States as well. States and local governments have significant information holdings associated with individuals. In fact, it's not uncommon for the quantity and detail of information to increase as proximity to the individual increases. So local governments have significant quantities of government-compiled data or personal information such as property ownership, court records, voter registration, business names, vital records, and so forth. Only about half the states have similar privacy acts concerning state government agencies' holding of personal information. So we kind of touched on in the last slide that California has some, and even Massachusetts has some, but not every state has privacy laws at this point. And most federal laws don't apply directly to local and state government. This lack of unified treatment has placed the United States behind many other nations with respect to this issue and has created safe harbor issues that regularly require time and effort to address at the highest levels of government, with a differing set of officials involved depending upon the source of the information. Safe harbor rules are a series of agreements to privacy handling across international borders. So there's one major difference between the United States and Europe when it comes to privacy. In the United States, the primary path to privacy is via opt-out. In other words, it's on you to tell the holder of that information you don't want them to share that information. Whereas in Europe, in other countries, it's just the opposite. It's opt-in. They have to get your consent before they can share the information. So the OECD Fair Information Practices are the foundational elements for many worldwide privacy practices. Dating back to 1980, the Fair Information Practices are a set of principles and practices that set out how an information-based society may approach information handling, storage, management, and flows with a view towards maintaining fairness, privacy, and security. Members of the OECD recognize that information was a critical resource in a rapidly evolving global technology environment, and that proper handling of this resource was critical for long-term sustainability of growth. The European Union has developed a comprehensive concept of privacy, which is administered via a set of statutes known as data protection. These privacy statutes cover all personal data, whether collected and used by government or by private firms. These laws are administered by state and national data protection agencies in each country. With the advent of the European Union, this common comprehensiveness stands in distinct contrast to the patchwork of laws in the United States. As you could have seen in one of the previous slides, there's a lot of different laws governing privacy in the United States. Here, they're able to cover it in a more unified effort using the European Union privacy laws. Privacy laws in the European Union are built around the concept that privacy is a fundamental human right that demands protection through government administration. When the European Union was formed, many laws were harmonized across the original 15-member nations, and data privacy was among those standardized. One important aspect of harmonization is the Data Protection Directive, adopted by European Union members, which has a provision allowing the European Commission to block transfers of personal data to any country outside the European Union that has been determined to lack adequate data protection policies. The impetus for the European Union Directive is to establish the regulatory framework to enable movement of personal data from one country to another, while at the same time ensuring that privacy protection is adequate in the country to which the data is sent. If the recipient country has not established a minimum standard of data protection, it is expected that the transfer of data will be prohibited. Canadian laws are neighbors to the north. Like many European countries, Canada has a centralized form of privacy legislation that applies to every organization that collects, uses, and discloses personal information, including information about employees. These regulations stem from the Personal Information Protection Electronic Data Act, which requires the personal information be collected and used only for appropriate purposes. Individuals must be notified as to why the information is requested and how it is to be used. The Act has safeguards associated with storage, use, reuse, and retention. To ensure leadership in the field of privacy issues, Canada has a national-level privacy commissioner, and each province has its province-level privacy commissioner. These commissioners act as advocates on behalf of the individuals to enforce privacy provisions associated with the Act. Asian laws can be pretty similar. Japan has a personal information protection law that requires protection of personal information used by the Japanese government, third parties, and public sector. The Japanese law has provision where the government entity must specify the purpose for which information is being collected, specifically to specify the safeguards applied, and when permitted, discontinue use of the information upon request. Hong Kong has an Office of Privacy Commissioner for Personal Data, a statutory body entrusted with the task of protecting personal data privacy of individuals to ensure compliance with the Personal Data Privacy Ordinance in Hong Kong. One main task of the Commissioner is public education, creating greater awareness of privacy issues and the need to comply with the Personal Data Ordinance. China has long had a reputation of poor privacy practices. Some of this comes from the cultural bias towards collectivism, and some come from the long-standing government tradition of surveillance. Recent news of the Chinese government eavesdropping on Skype and other internet-related communications has heightened this concern. China's constitution has provision for privacy protection for the citizens. Even so, issues have come in the area of enforcement and penalties and privacy items that have been far from uniform in the judicial history. Privacy-enhancing technology is an application or tool that assists in the means to protect privacy. Encryption is at the top of the list of PETs for protecting privacy and anonymity. Encryption can keep secrets secret and is a prime choice for protecting information at any stage in its life cycle. The development of Tor routing to permit anonymous communications, coupled with high assurance, low-cost cryptography, has made many web interactions securable and safe from eavesdropping. Other PETs include small application programs called cookie cutters that are designed to prevent the transfer of cookies between browser and web server. Some cookie cutters block all cookies, while others can be configured to selectively block certain cookies. Some cookie cutters also block the sending of HTTP headers that may reveal personal information, but may not be necessary to access a website. Some block banner ads, pop-up windows, animated graphics, and other unwanted web elements. Some related PET tools are designed specifically to look for invisible images that set cookies, which are often called web beacons and web bugs. Other PETs are available to PC users, including encryption programs that allow users to encrypt and protect their own data, even on USB drives. Policies and procedures are the best way to ensure uniform compliance across an organization. The development of a privacy policy is a central foundation element of a company's privacy stance. One of the direct outcomes of the legal statutes associated with privacy has been the development of a need for corporate privacy policies associated with data collection. With a myriad of government agencies involved, each with a specific mandate to assist in the protection effort associated with PII, one can ask, what is the best path for an industry member? If your organization needs PII to perform its tasks, obtaining and using it is fine in most cases. But you must ensure that everyone in the organization complies with the acts, rules, and regulations associated with these government agencies. And that's done through training your employees. Any organization that I've worked at that has involved the collection of PII or personal healthcare information, or any kind of protected information of that sort, has provided direct training on how to handle that information and how to protect it. And it also usually requires periodic retraining in order to ensure that we still fully understand and comply with the laws and policies involved. A privacy impact assessment, PIA, is a structured approach to determining the gap between desired privacy performance and actual privacy performance. A PIA is an analysis of how PII is handled through the business processes and an assessment of risks to the PII during storage, use, and communication. The following steps comprise a high-level methodology and approach for conducting a PIA. Establish PIA scope. Determine the departments involved and the appropriate representatives. Determine which applications and business processes needs to be assessed. Determine applicable laws and regulations associated with the business and privacy concerns. 2. Identify key stakeholders. Identify all business units that use PII. Examine staff functions such as HR, legal, IT, purchasing, and quality control. 3. Document all contact with PII. PII collection, access, use, sharing, and disposal. Document also processes and procedures, policies, safeguards, data flow diagrams, and other risk assessment data. Finally, document all contact with PII when it comes to web policies, contract, HR, and administrative actions. 4. Review legal and regulatory requirements, including any upstream contracts. The sources are many, but some commonly overlooked issues are agreements with suppliers and customers over information sharing rights. 5. Document gaps and potential issues between requirements and practices. All gaps and issues should be mapped against where the issue was discovered and the basis, the requirement or the regulation that the gap maps to. Review findings with key stakeholders to determine accuracy and clarify any issues. Before the final report is written, any issues or possible miscommunications should be clarified with the appropriate stakeholders to ensure a fair and accurate report. And then 7, create the final report for management. The Internet acts as a large information sharing domain, and as such can be a conduit for transference of information among many parties. The web offers much in the form of communication between machines, people, and systems, and this same exchange of information can be associated with privacy based on the content of information and the reason for the exchange. We kind of touched on this when we were talking about privacy enhancement tools, about cookies, specifically cookie cutters. But cookies are small bits of text that are stored in a user's machine and sent to specific websites when the user visits. Cookies can store many different things, from tokens to provide a reference to a database server behind the web server to assist in maintaining state through an application, to the content of a shopping cart. Cookies can also hold data directly, in which case there is possible privacy implications. When a cookie holds a token number that is meaningless to outsiders but meaningful to a back-end server, then the loss of a cookie represents no loss at all. When the cookie text contains meaningful information, then the loss can result in a privacy issue. For instance, when a cookie contains a long number that has no meaning except for the database server, then the number has no PII. But if the cookie contains text such as a shipping address for an order, then this can represent PII and can result in a privacy violation. But because of the potential for PII leakage, many users have sworn off cookies. This leads to issues with numerous websites, for when properly implemented, they pose no privacy danger and can greatly enhance website usefulness. The bottom line for cookies is fairly easy. Done correctly, they do not represent a security or privacy issue. Done incorrectly, they can be a disaster. A simple rule solves most problems with cookies. Never store data directly on a cookie. Instead, store a reference to another web application that permits the correct action to occur based on the key value. Information is needed to obtain services, and in many cases the information is reused, often for additional and secondary purposes. Users agree to these uses through acceptance of a firm's privacy policy. Shared information still requires control, and in this case the control function has shifted to the party that obtains the information. They may store it for future use, for record purposes, or for other uses. If they fail to adequately protect the information from loss or disclosure, then the owner no longer has authorized the uses in which it may be employed in. Data disclosures and information theft both result in unauthorized use of information. Users can take action to both protect their information and to mitigate risk from unauthorized sharing and the use of their information. So let's look at some actions users can take. Users have to share information for a variety of legitimate purposes. Information has value both to the authorized user and to those who steal the information and use it for unauthorized purposes. If users are going to control their information, they have to take certain precautions. This is where security and privacy intersects at an operational level. Security functionality enables control and thus enables privacy functionality. One of the aspects of maintaining control over information is in the proper security precautions presented throughout the book that we've read, so they will not be repeated here. A second level of actions can be employed by users to maintain knowledge over their information uses. The value of information is in its use, and in many cases, this use can be tracked. The two main types of information that has immediate value are financial and medical. Financial information, such as credit card information, identity information, and banking information, can be used by criminals to steal from others. Many times the use of identity and financial information will show up on the systems of record associated with the information. This is why it's important to actually read bank statements and verify charges. I myself have been the victim many times of credit card or identity fraud due to no fault of my own. Usually I've been able to trace it back by the credit card that's being used back to a data breach that has happened. But so you can do all that you can to protect yourself, but you're never going to be 100% safe from the misuse. But I'll tell you what has helped me in the past is I check my bank accounts almost on a daily basis. It's just a matter of habit for me. When I go to bed at night, before I go to bed, I check. And usually sometime around lunchtime each day I check. It's just routine. I'm not saying you have to do it that often, but you should do it often enough so that as soon as you detect a charge, you can report it immediately. And the criminals are getting smart with that too. So they often do a bunch of them at once, very quickly before you spot it. They'll usually test the activity of a card by buying some gas or something at a enabled gas pump to test to see if the card is still active, or the card number is still active. And if so, they go and they make very large purchases. What I have seen, most of them that have been involved in my particular credit card numbers have been with purchasing gift cards of very high value at multiple locations, usually within a couple of hours of each other, and then all activity ceases. And we've been able to stop the transactions as quick as possible if they go to a store that reports immediately. As some of you have noticed, sometimes you purchase something and it takes a day or two for it to show up, and in other times it takes just minutes, and you see that the withdrawal is already there, or the charge is already there on your card. These people have picked sites that usually take a day or two. They know what they're doing. They have experience doing it, and the same goes for your medical insurance and medical charges. You should be watching your evidence of benefits for unauthorized medical billing in your name. Failure to track that or failure to report unauthorized billing could make you complicit with with insurance fraud. So you want to make sure that you're also paying attention to any insurance charges for medical treatment that you've gotten. Data breaches. When a company loses data that has stored on its network, the term is a data breach. Data breaches have become an almost daily news item, with people actually becoming desensitized to their occurrence. Data breaches act as a means of notification that security efforts have failed. Verizon regularly publishes a data breach investigation report examining the root causes behind hundreds of breach events. The book discusses the 2014 report, but actually the 2017 report is now the 2016 report is now available. And one of the things you'll see consistently across the board, and when I think I talked a little bit about this back when we were talking vulnerability management. One of the common themes is that they use phishing against users to gain access to the network by having them click either a link to a fraudulent website or to open up an attachment that uses a vulnerability in known third-party software, such as Microsoft Office or Adobe Acrobat, or at the website maybe using Flash. So you'll notice in the industry when you get out there, when you do vulnerability management, you're constantly updating Flash, Java, and Acrobat Reader because they are a regularly used threat vector for these major breaches. But you'll see that there's a lot of them have to do with point-of-sale intrusions, web app attacks, insider privilege misuse. I think I've said before that insiders are some of your biggest risk because they already know what you got in place for security and they know where the valuable information is. Physical theft and loss, people losing laptops and mobile devices because they leave them in their car and it's got PII on it or PHI on it. And then miscellaneous errors, misdelivery or misconfiguration or user errors. Crimeware, the big one now, and you'll see in the 2016 report, is ransomware or CryptoLocker, payment card skimmers, denial of service, and cyber espionage are some of your biggest data breaches in the Verizon report each year. I'm your instructor, Peter Keurig for Nashville Community College. Thank you for watching.